So for those of you who were here last year, Miles actually talked to us about preparing for PI. So I have done it in a slightly different way. I've done the preparation from my own point of view, and I'm going to talk to you about things I think have changed in the last year or recent years, things that are having an effect on the way public inquiries are conducted and resolved. The key is going to be, obviously, you need to prepare, and it starts with the interview, but the theme runs all the way through it, which is actually easier than it sounds, because invariably, when you've got a hearing, you've also got a business to run, and you're trying to do a number of other things at the same time. But that is going to be key to, or a key theme, if you like, in the presentation. This is part of the reason, if you just think about the scale of you, how many of you there are, there's just no way that the Commissioner, that the DVSA can keep an eye on all of you. There's 75,000 licences, 370,000 vehicles. I mean, this is slightly out of date now because the annual report hasn't been published yet this year, but I don't think the figures are going to be very different. So sometimes people will come to see us and say, I'm in the process of getting it sorted. If you ask the DVSA to come out and see me again in 6 months' time, by then I'll have my ducks in a row. There's just no way they're going to do that. They just haven't got the resource to do it. By the time you get to your hearing, you really need to be able to demonstrate that you've already sorted it out. And if the Commissioner thinks you're going to take another 6 months to get there, they may not be inclined to give you the time. I've just published a few of the additional stats in relation to outcomes which tell us what happens at the end of hearings. And again, this has remained reasonably static over the last few years, with the exception of transport managers. For those of you who are transport managers, that role and the way that that role is regulated by commissioners, in my opinion at least, has radically changed. And I think that's evident from the number of disqualifications. It doubled in the last annual report, and it wouldn't surprise me if it doubles again. So the regulation is the same, but the way that they're being dealt with at public inquiry is different, I think. The Commissioner's going to talk to you a little bit about this later. I think, in essence, the bar has been raised about what is expected of you as a transport manager. So yes, you've always had to have continuous and effective management of the fleet, but actually now they're looking at that role much more carefully to make sure that you are doing it. What does it mean, continuous? You can't be there every hour of every day. How can you possibly have continuous control and management of it? Well, there are a lot of tools these days to enable us to do that. So remote downloading, access to digital tools, the smartphones whereby drivers can record their walk-around checks means that you can have access to that data from your front room while you're watching the presentations on YouTube. So that's changed. Most of the other stuff I don't think has. That in itself is a whole presentation. If you're called up, they should give you 21 days notice, and actually I think they hit that pretty consistently. What some areas are not quite so good at is getting the brief out. So they send you the letter, usually by email, but the brief doesn't come until a week, 10 days before. You can look at the KPIs for traffic officers in order to say, we really need, here is your KPI, you haven't met it, but it can be difficult. So what do you do if you get the brief a few days before? Well, you can apply for an adjournment, that mythical beast. Whether or not adjournment's going to be granted is set out in the stat doc, but in the last year I've applied for 2 adjournments. I'll give you a little bit about the facts of those cases. So the first chap is an unsophisticated operator, shall we say. And we get the brief and we have a meeting. I take his instructions and he is obliged to produce his raw data for all his recent driver's hours compliance. When that goes in, 3 days before, we get another report, which is really, really damaging. If it were possible, it's even more damaging than the first one. And I know it's going to take a little bit of time to explain what this might mean to this operator. So I apply for an adjournment on the basis that we've got this 3 days before. There's no way this chap is going to be in a position to deal with it. Did we get it? What do you think? Who thinks we did? Come on, who thinks we did? We did get it, but he wasn't very happy about it. They really don't like to grant adjournments because it costs them time, it costs them money, they're short of resource, it's difficult to relist, and chaps like my unsophisticated clients are eventually going to lose their licenses, and as far as they're concerned, the quicker they can get on with that, the better. Okay, second example, client receives the call-up letter by email when he's on holiday. Doesn't get back from his holiday until the day all of the material requested in the brief has to be produced. So he phones me and says, I've been on holiday for 10 days, I'm not back for another 2 weeks, that's when they want me to produce all this stuff. I'm never going to do it. Sends me the evidence of his journey, sends me the evidence of his accommodation, we supply it, we ask for more time. Do we get it? Who thinks we do? We don't get it. We don't get it. Again, that is what we would describe as a bad case. And I think that's highly relevant. If it is a bad case, you are much less likely to get it. And actually, that is included in the guidance. You need to make an assessment of what the outcome is going to be. If the outcome is not going to be favourable, you're less likely to succeed in an adjournment. Representation, this has changed as well, and for those consultants who represent operators at inquiry, you've probably noticed a change in this as well. The stat docs were changed last year in order to reflect this change. What they are now saying is, if you are a consultant or you are a non-legal representative, you must apply for permission to represent your client at PI, and you have to provide a copy of your CV. There's nothing wrong with non-legals representing clients at PI. It's not adversarial, and in some instances, it is very welcome. But the reason this caution has been built in is because there were a number of cases last year which had to be adjourned midway. Sometimes because of conflict, sometimes because the advocate strayed from giving evidence to then cross-examining, back to giving evidence, and the idea is that you can't do both. So if you are going to use somebody who's not legally qualified, that is permissible, but you have to satisfy yourself, if you are the advocate at the outset of the proceedings, that there's no conflict between the people that you're representing. What does that mean? Well, what that means is if you are going to represent them, you have to be able to do the best case possible for them as individuals. So the short version is, if he might chuck mud at him halfway through, or vice versa, you can't represent both. Because what happens is, you get there, you're stuck in the middle of it all, and it has to be adjourned, and then you have a very unhappy commissioner. Similarly, you may find that some advocates have got in difficulty because they are not sure of their status in the proceedings. You are either a witness, so you are there, you're going to go into the box or give evidence from the desk, and you are going to talk about improvements that you've made, issues that you've appreciated, and that's it. Or you are going to make submissions on behalf of the operator. So just be clear about what your status is in the proceedings. After that, sounds obvious, read the papers. In my experience, as much as 70% of operators never read them. I think that's partly, I know what's in there and I'm not going to like it, so I'm just not going to read them and hope it's not as bad as I think it is. But actually, it's quite difficult to deal with issues unless you know exactly what is alleged. So that is a good starting point, because that helps you to work out where this lies in terms of a strategy. What is the commissioner going to make of your case? What is the best way of approaching it? Do I need to be thinking about an additional layer of management? Do I need to get rid of one of the directors? When you've decided the strategy, it's a really good springboard for all your other preparation. And that case, I don't know whether most of you have heard of this case. It's a key case, Arnold. Miss Bell often refers to this, as do other commissioners. And it basically sets out 4 types of operator. So you've got the first one who they get in difficulty, they take immediate steps to remedy it. They know what the problem is, they put a solution in place. They're number 1. Then you get the second one who thinks, I want to wait and see what happens. They get the call-up letter, panic, and they then start to put things in place, call their consultant, get them out, do an audit, etc. That's the second type. Then you get the ones who go to PI and say, I haven't got around to it yet. I've been really busy. I absolutely promise if you give me a chance, I'm going to get it sorted out. And then the last one who goes to PI and says, what do you want me to do? Tell me what you want me to do and I'll do it, Governor. And what they're saying is, actions speak louder than words. If you wait until the day to be told how to run your business, it does not inspire confidence in you. You need to get steps in place before the hearing to show that you know what you're doing, because if you go back to the stats I put up there earlier, there's no way they've got time to manage your business for you. The other thing I think has changed is applications. So until a year or 2 ago, you could decide your strategy, which was the old TM was getting the heave-ho, and we were going to bring in this new one who was a shinier, brighter, faster, quicker, digitally savvy version of the old one, who was going to salvage the whole operation, and here he is, or she is. But actually, that doesn't work so well now, because you've got to get your application in before the hearing. Well, why? Why can't I just turn up on the day with my TM1? Well, there has to be background checks of your proposed transport manager. So they've got to run some checks to make sure he's not on 3 other licenses, hasn't already lost his professional competence or repute. So you've got to be, again, prepared early. If you think your existing license might be revoked because actually the partnership has dissolved, or you've been working as a limited company for a little bit of time, they're the usual ones. Don't put your application in the day before, because your existing license is going to be revoked because you're no longer working as that legal entity, and she or he can't grant the new one because it's only just gone in. It's got to go through the statutory notice period. It's got to go through applications and decisions. So whereas previously, I think, even a year ago, you might call a proposed transport manager to give evidence. TC liked him. Yeah, okay, your nomination is accepted. And bingo, on the your plan B is in place. So I would say that approach is we're finding difficulty with it. And if you've already got a string of issues, you don't really want to also have to apply for a period of grace to get someone in place, because it just adds another obstacle on the day. Had a few other issues come up this year that I thought you might be interested in. Had a couple of operators who, when they bring their paperwork, they don't bring their paperwork, and you say, where's the PMIs? This one, they've gone in the skip. What skip? There was a mix-up and all my PMIs went in the skip. Right, and I think he thought that that would be a reasonable explanation to put forward. I've had other cases where people have said they've been eaten by mites, and actually they think this explanation again is going to be reasonable. It came up in this case, which is the Taxi Gwyneth case. An interesting one to read if you're having a sleepless night. In that case, they said the papers had been damaged by fire, weren't able to produce them, and the traffic commissioners couldn't decide. Maybe they were, Maybe they weren't. He suspected that they weren't damaged by fire, but of course, it's a balance of probabilities. So he found himself in difficulty in the decision. And actually, the upper tribunal said, you don't have to be sure there was no fire if the PMIs or the driver daily defect reports are not stored securely, and it's their only copy, obviously, a regulatory breach has occurred, and so that's enough for them to take regulatory action. So don't go for the dog get it line. It's not gonna fly. Periods of grace. I don't know whether you've crossed this. On application, of course, you can't have one. So if you're applying for a license, you've got to have the 3 mandatory requirements in place. You've got to have a transport manager, if it's a standard national or international. You've got to have enough money, and you've got to be of good repute. You can't apply for more time to sort that out. If your TM leaves before your public inquiry, you're not going to get it. On an existing license, you can ask for time. So if you go skint, customer goes bump on you, or your TM leaves, you can write to the Traffic Commissioner, let them know, ask them to make an adverse finding, and ask them to give you time to get someone new in place. There have been lots of issues this year, licenses getting revoked, whereby people have put the application in on the day. Let's say they give you till the 1st of August to nominate a new manager. You nominate him online on the 1st of August. No good. Hasn't gone through these background checks, and you find your license is revoked. So again, applications in early, apply for your period of grace. It's also having an effect at public inquiry, because you turn up on the day, you say, actually, the transport manager has not been in position for a number of months. Sorry, I didn't let you know. Here's the new one. Well, they're not going to be too happy about that. You've got to ask for the adverse finding to be made and ask for time to get a new one. It's just a little bit more transparent. Will you get it? Well, if it's money, what they say is, in accordance with the same case, the Taxi Gwyneth case, they're only going to give you time if there's a realistic prospect of you getting more cash. So you can't just write and say, I need more time, I've gone skint. You need to say, I need more time and I'm going to have more resource because this job's going to come to fruition, I've got a vehicle coming off finance, or whatever it is. Issues and presentation. I was at a hearing just last week before one of the deputies, and the operator was giving evidence and talking about all the problems generally of being an operator, and there are many, and that could take up quite a lot of the hearing time. And what she said to him is, I know what the problems are, I've read the brief, I'm looking for you to tell me what you've done about it, what you are doing about it. It's the old, you need to go, I know what the problems are, and this is what I've done. Problem, solution. And don't be afraid of doing that. I think some operators are nervous about setting out what all the issues are in the business, but actually it just looks like you know what you're doing, like you've got your finger on the pulse, you've actually identified what the problems are. And there has been a bit of a shift, I think, in the standard, perhaps rightly. When the Norbert case was published on appeal nearly 20 years ago now, this was a bad driver's hours case, but they were historical. And by the time they got to PI, things were much improved. And at the appeal, the upper tribunal, or transport tribunal as it was then, said not sufficient account had been taken of all of the changes which the operator had made in the meantime. You're entitled to be judged as you appear at the day of the hearing itself. In other words, it's worth getting your finger out, because if you've got it sorted by the date, they're going to take account of that. But that was watered down, I think, in 2014 after the case of Randolph, when they said sometimes, though, the present is just a culmination of past events. So if the historical issues are creeping into the current ones, even if you're much improved, you need to put some space and time between you and what's gone before to rely on that. I'd be interested to know your views, but my own experience of doing these hearings frequently is that a lot of the things that you might get wrong but can be remedied, the commissioners are keen to work with you to find a solution. They're keen to hear that you're going on training, that you're going to improve. It's the cases where you lack integrity, where you've tried to smooth something over, make it look better, or worse, where you've given evidence or said something that wasn't quite true. And that's an easier thing to do than it sounds. You're in DVSA interview, they're asking you about something that you feel is going to be a difficult area for you. The best thing to do, almost invariably, is be honest about what's happened and talk about what you've done to prevent it happening in the future, if you've chosen to give an interview. Now this, again, I think is happening more frequently. Don't be afraid to pitch it. What do I mean by that? Well, read the Stat Doc 10. If you just Google it, it sets out what areas of concern, what issues there are, and how serious that means your case is. So you read those, you work out what category you fall into, and you pitch it in a certain area. Now this is something operators feel very nervous about because they're hoping that you've got it wrong and actually nothing's going to happen. They're going to go in, have a nice chat, perhaps a slap on the back, and carry on as they were before. But I don't think that's the right approach to take. There was a case in 2014 where Leonida go along trading as ETS, and they don't make submissions about an outcome. They just hope it's going to be okay. And there is a significant regulatory outcome. I think it was a suspension. And they appeal it and say, well, you may as well have took my license off me because I can't fulfill contracts without a license, even if you just take it for a week. And what the upper tribunal said is, if that's the case, you need to tell the commissioner that. Because if you don't tell them, and then they take action against your license that you don't like very much, you can't really complain about it, particularly if you're represented. The idea is that you're going to go in there and say, I think this is a moderately serious case. I think the proportionate outcome is a curtailment of 4 vehicles, and this is why I say it. So if you're a little bit nervous about that, I still think it's the right thing to do. And going on from that, commissioners increasingly are giving indications of what they think the outcome is going to be. It's always happened in the Crown Courts, but now it's increasingly creeping into public inquiry. So the commissioner might say, I haven't made my mind up yet, but I think this is a case whereby a short suspension is appropriate. And you would say, thank you very much. May I take 10 minutes? You all scuttle outside. What do you think about that? How's that going to affect your operation? And then you can deal with it. You can make submissions. So it means that you're more likely to get an outcome which doesn't put you out of business. And so it all goes back to that initial starting point of spending as much time as you can. I almost invariably advise operators to get a transport consultant into the business at a fairly early stage, just because if you've got an extra pair of hands, boots on the ground, they can apply various known tools, compliance, whatever, to help you get your ship in shape.